Okay, good afternoon and welcome. Thank you for joining us for another episode of Discuss with Russ. I'm Russell Rivera, founder and president of Voice Wealth Management, and this is our 17th episode. My guest this afternoon is Anthony Verna, managing partner of Verna Law. Our topic this afternoon is making the most of your opportunities during COVID. We'd like to welcome all of our viewers on Zoom, Facebook Live, and YouTube. For those of you tuning in today for the first time, the Discuss with Russ series has focused on helping you get through the crisis and start thinking and planning for what the world might look like as the crisis dissipates. Now that we can leave our homes, see each other face to face again in most places, we want to help you anticipate possible responses in society's behavior so you can be most prepared to succeed. My firm, Voice Wealth Management, primarily works with entrepreneurs, young professionals, and their families to help them get the most out of their money. While I'm a chartered financial analyst and certified financial planner, many also see me as their personal CFO and financial therapist, recognizing the psychological power of money in addition to using short-term and long-term planning to help you get the most out of every dollar you earn and use. Now on to our guest, Anthony Verna. Anthony is managing partner of Verna Law. His practice focuses on patent, trademark, copyright, domain names, entertainment, and advertising law, providing the intellectual property services a modern business needs to market and promote itself. He also provides counseling and other services to help clients grow their businesses. His clients come from all over the globe, but the firm has strong presence on both coasts of the United States. He has over 15 years of experience practicing law regarding intellectual property issues. He got his bachelor's degree from Case Western Reserve, his JD from Rutgers Camden, and is the host of the Law and Business podcast. As for housekeeping issues, there is a Q&A tab for asking questions, so please use that button to ask questions of our panelists. And this web show is being recorded. We will tell you how to get a recording at the end of the program. And with that, Anthony, thanks for joining us today.
Hey, Russ, thanks for making me sound really important there.
Well, that's my job. That's what we're trying to do here. So we have spoken a lot about how things have been going for you, this crisis offline. We've been talking together for several months. I've made comment that you were my last handshake. And it seems like for your business,
it's an honor.
Yeah, I'll never get that stench off. But it seems like for your business, you're seeing people think in concert with the saying that goes, with great uncertainty comes great opportunity. What are you seeing in the intellectual property world, and why do you think that is that you've been so busy over the last several months?
Well, I'd begin with, there are two separate thoughts on that. One is on the positive side of life, which is that whether people are home because, of course, we're required to stay home more than we are, and basically that leads to less of a commute, just more idle time on our hands, more TV time, whatever the case might be. People also have been laid off as well. So whether somebody's unhappy with work, is unhappy, or has lost work and just has lots of time on his or her hands, or companies are working from home and they're finding themselves being more efficient and creating something new. There's a whole lot of new creations right now. So from the patent and trademark side, on the positive side, we're seeing more patent applications come in. We're seeing more trademark applications come in. And that's just because there's a culture of creation right now, whether that comes from the celebration, maybe even worship, a little bit of entrepreneurship, but also the fact that I just think there's a lot more time on people's hands right now than before the pandemic. And so from that particular standpoint, that's why I think we're seeing more patent applications come in. On the negative side, and I do consider litigation to be a negative portion about what a lawyer does, because effectively litigation means that there's a problem and we're asking a third party, the inefficient court system, to fix it. So on the litigation side, I think we're finding that more people are looking for copiers and infringers of their own intellectual property. And that's because, somebody's at home at work and has more idle time on his or her hands. And so more business owners are are putting that together and finding that. But also, frankly, during this pandemic, there's a whole lot more fraud than I've ever seen in my life. And I've seen certainly lots of different aspects of it helping clients with different situations, but we're just seeing it out there that I think a lot of people are trying to sneak some kind of fraud by other people's noses. And I think from an infringement standpoint, we're seeing more copiers out there.
So give me an example. I'm not sure what you mean by that. And why is it, do you think it's more that there is actually more fraud, or it's just more being kind of caught?
Yeah, it might be more. It might be more seen right now, but certainly in international transactions, I think a lot of my clients are seeing that they're just seeing the copying out there. I don't know that I'm allowed to give you a specific example or how I know, but certainly with fraud, a lot of international business transactions that my clients want to perform are just not happening. And that's happening, for one particular reason or another, just parties are pulling out. And I suspect it's because they claim to have the money that they really don't have. And then they get sniffed out. So on the international transaction side that my clients have, we're seeing that a lot. But we're just seeing more copiers than ever. And I don't know if that's the result of the pandemic or just something that my small subset of clients have particularly seen themselves.
Right. So it might be anecdotal and not necessarily a real pattern of what's going on.
Correct.
In your stuff. Fair enough.
Yes.
So going back to the more positive side, seeing people now trying to create things. So what do you think all of the changes in your world are mean for business formation, right? We've talked about maybe it's somebody who wants to do something small and goes out and does something, gets around on their small business to getting a patent or something like that while they have nothing else to do. But does this mean from your experience that there is actually a business formation happening now that we are in a rapidly changing environment?
Well, I mean, again, I think anything that I might give you on a numbers side is completely and totally anecdotal, considering we're a small shop of 3 professionals and our client base may or may not be a representative sample, and I would probably lean towards may not be a representative sample of what's out there.
I'll wait for the state business formation data for this, but I want to hear what you have to say.
But that said, we're noticing through our front door, more people coming in. So it certainly sounds as if more people are creating businesses with unique products, with unique branding. And we're certainly seeing that happen. Our inquiries are just up and through the roof since the pandemic started.
And is that just because, again, is that mostly because you think the opportunities are out there because, again, the world is changing so fast, or because these were backburnered, or?
I think it's a combination of both. I mean, the world was changing fast even before COVID hit. But, in a way, COVID kind of pushed us into that 21st century that we were kind of always promised, right? You and I are recording this on Zoom, setting this on Facebook Live. You and I have not met in person for months upon months, but isn't this what we were promised, that you could sit at home and do all of your work at home? And yet employers weren't really letting that happen. Yet meetings and groups weren't really letting that happen. Even though, frankly, I think a lot of us do prefer face-to-face contact instead of video screen to video screen contact. But ultimately, the world was changing because Zoom existed before the pandemic. Skype existed before the pandemic. It was there, but we were now forced into this. So I think the changes were there, and I think the world was changing even before the pandemic. And I think with all those changes, with the fact that we interact with software, not just on our computers, but now also on our phones. And we have been interacting with software on our phones for the past, 15 years at this point. There's now the Internet of, now there's the Internet of Things. And if you're not buying, I will tell you, my wife refuses to get an internet-ready television. And so our newish TV is not an internet TV, and she refuses because she's like, "Have you read the privacy terms?" Yeah, I have read the privacy terms, so I agree with her.
I would trust you for that more than anyone else on the planet.
Exactly. But you could buy a lamp that's internet ready, and it's going to have terms and services and conditions of use because it's going to interact with the internet. So now we're buying lights, and so we're interacting with software everywhere. So I think a lot of people are thinking in that mode as well, rather than it being a specialty. It finally, the internet and computing is really truly a home appliance that people interact with all the time and can think with.
I want to come back to that topic a little bit later, because I think there's a lot to be said for privacy, but we'll double back there a little bit later.
I thought you were going to say with familiarity, because I think a lot of invention comes with familiarity of things.
What do you mean?
So, you might have an idea for a system, and that system, the steps of that system might work as a method pattern or an algorithmic pattern, however you want to define that. But if you don't know how to implement that and turn that into a business, say via software, or understand that how you have to put together that, then what good is the method? But so when 15 years ago, when smartphones were finally coming out, if you had an idea for a method, but maybe you weren't a coder, maybe it wouldn't have come into your head that, oh, gee, I could put this in software and put it in a code, and then it's here on this device ready for everybody to use. Well, I think today, 15 years later, people are actively thinking that way as well. So I think creation comes with the familiarity of not just having a computer, but also having software as an everyday need.
So basically, people are saying, so let me see if I can encapsulate this a little bit. So people are saying, hey, they understand the idea of trying to get an idea into software because they're doing it all the time. And yes. So it's great to say, I have a new way to do stuff, but you have to be able to translate that from idea essentially to code, and then into an actual software package that people can interact with.
I think so. Absolutely. Yeah.
Well, my son's been doing an app camp all summer, and he's got a great idea. And he's 11, so he's not fully up on all of that. So maybe we'll have to put it.
Well, look, but that's okay, because when I was 11 and my friends and I did a Pascal coding camp, we were seen as the weird freaks, Yeah. That's that's what I'm talking about.
And now anybody can take Harvard CS50 for nothing.
Exactly.
Yeah, absolutely. We will come back to the privacy, because I think there's a whole thing we can touch on there, but we're talking about the new business formation right now. Why do you think it takes a crisis like the one we're in to unleash the creativity that we're seeing and that you're seeing in people?
I don't know that it necessarily takes a crisis, but I just think right now, the reason why this crisis has translated into what we're seeing as more work, my best guess is just that people are home, right? We were all told to stay home. So now you don't have to travel an hour to work. So that's 2 hours a day that you're not traveling to work. Well, if you're still going to start work at 9 a.m., you've got a morning to think about things. Or, at 5 o'clock comes, and if 5 o'clock's your quitting time, 6 o'clock's your quitting time, I'm working till midnight. But, whatever your quitting time is, you've saved now 2 hours on a day if you have an hour commute. If you have an hour and a half commute, and more Americans have an hour and a half, 2 hours commute, you're saving 3 or 4 hours a day for you to think about things. And I think that's really where it comes from, is that this crisis caused people to stay home, and people are thinking about things. And I think that's what it is. And I think people are just creating more because the daily routine isn't there anymore.
Well, there is the statement, necessity is the mother of invention, right? I mean, obviously, some of the things that we're dealing with is from necessity, but I'm also sitting here thinking, I can only imagine the things I could think up and dream up if I were sitting on Long Island Railroad or Metro North on a daily basis, right, and had that hour.
Nah. Come on. Come on. I hop on the train and I put headphones on and I close my eyes. And they don't look like these headphones. They're regular headphones. and I close my eyes and I sleep. I don't know how. The only people that I see
That's because you work till midnight.
Well, yeah, I mean right now. The people that I see working on the train are psychopaths, frankly. I don't know how anybody gets any work done on the train. I sit on the train and all I want to do is close my eyes and get more sleep because it's a long commute. And I have one stop and then it's straight to Grand Central, but I'm still on the train for an hour. If you're on the train, you're not getting, you might be like getting a narrow slice of your work done on the train, but you're not having that burst of creativity on the train.
Well, that doesn't provide you personally the time to think.
No, I close my eyes on the train.
Fair enough. Fair enough. Understood. Fair enough. So I do want to change before we will get to privacy later, like I said. And by the way, if you do have questions, you can use the Q&A tab at the bottom. Anthony and I will see them right away. And if they're appropriate or valid, we'll be able to take a look and respond. In terms of, it seems that many very small operations, entrepreneurs and the like, don't go through the legal steps to protect their work, mainly because of cost of getting off the ground. So this could be, for people who have been coming to you now, maybe wouldn't have before, and now we're doing it. How much of people's work can be protected without going through the trademark or patent process? And when's the right time for them to invest in the protection that you would advise that they need?
Look, I tell everybody start at the beginning. And I understand that for some people, it's definitely going to be out of reach at the very beginning. But you have to have the conversation at the very beginning, because if you don't have the conversation at the very beginning, then the chances are you're going to have some problems down the road. So, I mean, look, I've spoken to people who have spent $60,000 on their patent protection. I mean, we're a lot cheaper than that. And so I'm kind of surprised when I hear that a startup really wants to spend that kind of money, because I think you could get similar high quality services from firms that charge a lot less. So number one, I would say, call, speak, ask around, because at the beginning we can at least tell you some thoughts, such as the second that your invention is out, you have a year to file. And when I mean out of whatever secretive hole you put your invention in. So the second you tell your cousin, your brother, your neighbor, your sister, your mother, your father, you have a year to file it. Sorry, because none of them filed a non-disclosure agreement with you. So you have that year. So that's why it's important to speak to counsel to make sure that if you need to file a patent, you know exactly when your absolute drop dead, last day is. So that's important as well. On the trademark side of life, maybe you want to have that conversation to talk about just what steps do you need to take to make sure people aren't going to sue you, rather than the positive step of taking the trademark and actually registering it. So, the conversations for us at the beginning, I hope, encompass more than here's what you have to do to file it. I hope that there's I hate these buzzwords, but I hope we have a holistic, look, I didn't say synergy, right? I hope we have a holistic conversation about your products, your company, your branding, and what your needs and requirements are. That to me is more important than getting you in the door as a client. But frankly, if we don't have that conversation at the beginning, it's a lot harder. If you come to us and you say, well, I've had this invention, I've been selling it for 2 years, I'm gonna say, where the hell have you been? Because it's just too damn late at that point. Mm-hmm. You have to know and understand it's too late. So especially since the America Invents Act was signed, our patent law has radically changed. And I know at this particular point we're really even talking about a decade into the AIA. But a lot of people don't realize that you only have a year between telling people about your invention and actually filing it, and that today the patent office is not a first to invent, which is our system, which is what it was. Now it's first to file your patent. So it's really important to get into the patent and trademark office with your patent if you're going to do it. So yeah, to me, I want somebody to call me as early as possible. The sooner the better. And we'll have the full conversation about what the company's needs are, what the inventor's needs are. That part of the conversation isn't a problem, but you gotta come early. If you come to me 2 years, in and you haven't filed, it's going to be really hard to help you.
Fair enough. And so, you mentioned specific things. Obviously, you're talking about. Are there finer points regarding, obviously, patents in terms of inventions and new processes and whatever that might mean, and trademarks in terms of that 1-year rule?
Well, trademarks aren't subject to that particular rule. But what I would say on the branding side of life is that you do want to at least have a conversation about what other companies might be using similar brands to yours. Maybe you have a question about filing that and keeping that brand the same worldwide. I just spoke to a company from Lithuania that wants to keep that basically wants a worldwide brand. And, the United States might be a roadblock for this particular company. Why? Because even Burger King doesn't have a worldwide brand. Thank you, Australia and Hungry Jacks. So it is. You go to Australia, they're Hungry Jacks. Because Burger King was already in use. So you see the difficulty for even a giant conglomerate to have a worldwide brand. So it's going to be difficult for the smaller companies. But on the trademark side, that really is getting your butt to the patent and trademark office in every country that you want to sell in. So again, there might not be a hard and fast rule for trademark law, because in the United States, use in commerce matters. So if you have used your trademark before somebody started filing theirs, you're going to be golden, but it's going to take a lot of effort now that you let somebody else file. So again, the sooner the better. I don't really have finer points for that, but the sooner the better in all intellectual property is just the rule of thumb.
So it's basically the second you're ready to let it out of the bag, get the legal protection on those particular rights.
That would be my advice. That'd be the easiest, smoothest way of doing it.
Yeah. So you touched on this before. Myself, my son love Shark Tank. I'm sure you've got a lot of people in your world who, I'm sure, critique it highly in its own way. Because I know it's obviously you could critique it highly many different ways, I'm certain. But anyone who's watched it always they're asking, do you have patent protection? Do you have trademark protection? The whole thing. And sometimes it's just necessary to be able to create a business asset, right? Like in terms of having it, whether it's something that you can defend. I've seen publicly listed companies whose basically only business is defending, is basically defending patents. That was the entire reason for existing. But you were mentioning sort of the idea of algorithmic or method patents. Can you go through a little bit more about what those are and what isn't protectable? Because I've read a bunch of different things, and I'm not an attorney, so I'm just utterly confused.
Sure. So and trust me, it's confusing for a lot of lawyers too. So I don't want to sit here and say that there is a what isn't protected kind of list. But software, algorithms, business methods, other methods are a lot harder to protect today than they were a few years ago. There's a Supreme Court case called Alice, and effectively, well, let me give you a little history. Somebody would try to enforce a business method patent or some other kind of method patent. It'd go up to the Supreme Court, and Supreme Court would say, we're not saying all business method patents are void. just this one. Just this one. And then a couple of years would go down the line, another one would get to the Supreme Court and say, you know what? Not all business methods are invalid, but this one is. and then it'd be like just complex thoughts and philosophy on why is this an invention or why is this not an invention.
Right.
And it's so very heavy fact specific, and it really only applies to the one case. So Alice comes up, and the Supreme Court says, okay, we are not saying all business method patents are valid, but they have to, they have to have an inventive step. They took everything that they had written before and they condensed it into this phrase that doesn't exist anywhere in the parlance of intellectual property law, the parlance of patents. And they say it has to have an inventive step. It's not in the statute. We don't know where they pulled this phrase from. And this is why I keep begging the Supreme Court to have like one intellectual property expert on it, because like stuff like this happens. I mean, they do have some very good 9-0 decisions on IP, but like every once in a while they just screw things up. And this is one of those times because nobody has any idea what that meant.
Right.
And the Patent and Trademark Office even took all method patent applications and they put them aside, and it took the in-house legal team 6 months for the Patent and Trademark Office to decipher that case and issue guidelines on how to judge business method patents, patent applications. So we have this history in the court system of disfavoring method patents, algorithm patents. So that's issue one. Issue two, we have this language in a case that doesn't come from the statute. It has to be new and novel, has to solve problems, but now it has to have an inventive step to it. So the advice that I tend to give new clients, potential clients, is tell me what efficiencies your method has. So are we saving processing time? If we're talking software, are we saving people time? Are we saving money? Are we saving, tell me about the efficiencies in your method that allow us to say, well, this is what's inventive about it. Like, to me, how's that different from new or novel? I'm not really sure. And philosophically, I'm not really sure how to answer that either. But it's harder to get it. So you have to maybe narrow your scope as to what that algorithm or software is. You have to understand going into this that you're going to file, and 18 months down the road, the Patent and Trademark Office is going to hammer you, and you're going to have to fight it. So you have to be prepared that if you're going to be filing a patent application revolving around software, revolving around methods, revolving around algorithms, it's just going to be harder to get that registration. And that's why, because it's just disfavored in the court system.
And so that means kind of, right, when I hear business method and I hear it, and to me it means something a little bit different than algorithms. So when I think about algorithms, I'm actually thinking about code, right?
Sure.
I mean, to some extent, code, to my understanding, is very standardized. So you are just using the code to do something different. I guess that might be inventive.
So let me say this. If we're talking the specific code that you write, let's put that aside, because patent law protects the invention, and I don't care if you write that invention in old K and RC, in C++, in rational rows. I don't care what language you write your code in. If 3 people create a program that does substantially the same thing in substantially the same way to get substantially the same results, all 3 of those people, regardless of what language they coded in, have created the same software under patent law. Patent law is all about the method of doing it, the steps of doing it. Now, the code itself if you want to talk the code itself, that falls under copyright law as basically a literary work is what we call it. You type out your code, here's what it looks like. Under copyright law, those three people did not create the same product because they did it under different programming languages, under different syntaxes, and so it looks different, it reads different. Copyright law is only going to protect the specific code that you create. It's not going to create the actual product. That's what patent law is for. So that's why when I'm talking about methods, I'm talking about algorithms, I'm talking about the overall view of how this works. And that's kind of why I'm interchangeably saying methods and algorithms, because you can have an algorithm that involves how you use satellites. And you can bounce information between satellites, or you can look at satellites and look at information, things like that. I mean that's some of the stuff that you can do. And we're not even talking about stuff from a bad 90s movie. I mean, we're talking you can see changes. So you can take that information and use it in a method. So that's the kind of stuff that's okay and acceptable. But again, copyright law will only protect the actual code that you type. Patent law will protect the overall
what it does,
product and how it does it. Yes.
Right. What and how it does it. Gotcha.
Correct.
So that clears some stuff up for me as a layperson. So thank you.
You're welcome. I try my best. I know that this stuff is confusing, but if you don't practice it, I've been there, done that.
Yeah. So heading back to the privacy question, you mentioned obviously all these things and how we interact with them every day, and there are so many questions as to how like for example, this morning one of the things I got an article about for people in my business was kind of if you're not up on all the privacy, all the whether it's hacking or everything else, and if you don't get up on it, it's going to hurt your business long term. And I'm sure it will. But when we're like I'm a layperson and we're dealing with 30 different EULAs and user license agreements that take 3 hours and someone like you to read and or write, how is just a person trying to get around in the world, supposed to understand how they're interacting with all these things that they've bought and protect themselves from not doing something they don't want to do, right? Whether it's, giving data away or whatever it might be.
Yeah. I don't know if I have great, wonderful advice about that. Because you're right, some of it is very confusing. I will tell you right now, my general solution: there is no Alexa in this house. There's never going to be a Google Home in this house, and my Siri, hey Siri, Siri doesn't pop up. The screen pops up, but Siri doesn't pop up, so it's not listening. My point is that, from a privacy standpoint, unless you're avoiding some of this, there's probably not much that you're going to be doing. Once you start allowing the devices in the house, from a privacy standpoint, you're just not going to be able to stop it, because there's going to be terms and conditions. And those terms and conditions are, Alexa doesn't work right unless it's on all the time and listening all the time, and comparing whatever is said into the microphone or whatever microphone hears to the proper wavelengths, that it's supposed to be hearing. And it makes those decisions on the server level, not on the local level. So I don't know how to give good advice when all of these devices are going to have terms and conditions. And yes, they're going to be longer than you want them to be. Sorry. But some of this is going to be, I think, but I also think what's going to happen is, and you're going to see this soon with, iPhone users, you're going to see this with Apple's iOS 14, which has greater privacy control. I think you're going to see that there's going to be more control over this. Your TVs, if you're buying a smart TV, sorry, it's recording at least it's recording the kind of activity that you're doing, and it's sending it to the servers. And you're also a part of whatever data collection system and selling that they're doing behind the scenes. It just is. If I showed you charts from other industry conventions that I've been to where we talk about data privacy, and you saw how your data is sliced, diced, and julienned to within an inch of its life, just so that some company can sell your ad space when you click on a certain link at a penny more for you than for somebody else, you probably would never use the web again unless you had, containers and other kind of ad blocking software on
And yeah, no, and and of course, when you're dealing with smart TVs, you have all the rumors of, oh yeah, there's software so the government can listen to you
it. It ain't the government.
If you want to go down that rabbit hole.
It
I
ain't
have
the
no idea.
government. It's the OS that runs the TV. All of that data of what you're watching is sent behind the scenes so that once again they know, the IP address for that TV is the similar IP address for your laptop. So
Right.
they know who's watching. There are data algorithm companies who know if it's you or your wife using your tablet just by the website you watch and the web
Well,
behavior.
that's obvious, sure.
Well, you say it's obvious, and 5 years ago that was a remarkable algorithmic discovery on that, how to change that. Yeah.
Yeah. And in some way, in some ways it's good. And obviously we see a lot of people who are very happy about it and don't mind getting those things that are relevant to them. And other people are like, I looked at this once. Why is this popping up? That's very scary. So you have people
Because
that
you
can
looked at it once.
Yeah, no, I know. I'm reminded when I was working in an old position, and it was like, okay, we were talking about looking at I'd heard, hey, look at this company and see what they're doing with physical gold. They were just, it was, again, for an old job, and it's like for a month, every banner ad was that company. That's the way it was. And had to, and that's the way it is. I'm sure many people are seeing that on a daily basis. And if they're using other things like in others. So, I mean, in terms of somebody really has an issue, actually, it's a really question to ask you if so some people use VPNs. Is that a way to deal with some of the privacy concerns, or are there other tips and tools that if someone did have a concern that about that you can share from your end?
I mean, VPNs are one way of handling it for sure. They're not foolproof.
Mm-hmm.
But what I would say is other kinds of software like uBlock or Privacy Badger, whatever is able to. I think Firefox has something built in called Facebook Container, which basically keeps Facebook on in the Facebook tab, and when you open other tabs, Facebook isn't tracking you. So there are tools and tricks out there. Multiple browsers. If you're familiar with the Tor browser, as well. I mean, Google's going to yell and scream at you, and you'll never get on Google from that browser. But those are just some pieces of software that might be ways to go. Yeah. Really, it's about protecting the privacy. So you're going to have to find ways to block cookies and other trackers.
Fair enough. So, I know this was a little bit, this end you was brought up, the privacy end wasn't what we were originally going to talk about, but it seemed adjacent to what you were doing, and knowing that you have this expertise and can help in that way. I appreciate you taking those questions.
Not a problem.
Yeah, any final thoughts, words? Actually, we haven't had any questions. I'll do a last call for questions for people who are watching, listening, at least in the Zoom. I know if you're on Facebook Live, we're not checking that, but we'll tell you how to reach out to us afterwards. So any final thoughts or words or things that you thought we needed to cover that we didn't?
No, not necessarily. What I would say is that when it comes to intellectual property, make sure with your creation, whether however you define your creation, you think about the protection early. Think about it from the very beginning. Like I said, we like having a very full conversation about what your goals are, what you're looking to do, why you need to protect it. And I would just say, whoever you speak to, make sure that you're comfortable with them. I mean, we've had people call our office and they're not comfortable with us. Personalities are different, and you want to make sure that especially when you're dealing with legal counsel, that it's a personality that meshes with you and you trust.
All right. Very good. Thank you. And so how can people contact you, Anthony?
Thanks, Russ. So it's easy to find us at Verna Law, VERNALAW.com. You can also give us a call, and I mean, you'll hear the building's receptionists are at home just like we all are, but bother them at home. 914-908-6757 is our office number.
Great. You know, I want to thank Anthony Verna of Verna Law for joining us today on our newest episode with Discuss with Russ. I want to thank everybody who joined us a half an hour late today. You know, but next week we'll be back at 2 o'clock. You can reach me at Russell, RUSSELL.Rivera, RIVERA at voicewealth.com. Or give us a call at 646-630-0980. We will be sending a follow-up email with the link to the recording, which will be eventually found on www.voicewealth.com/blog. Or you can view all of our videos on the Voice Wealth Management YouTube channel. Next week, August 12th, Jack Craven, CPA, will join us to discuss what to do if you haven't filed your taxes. And on August 19th, Aaron Shipp, CEO, president of the Ivy Edge and assistant or adjunct professor at NYU, will join us to discuss the rapidly changing situation regarding higher education. If you'd like to register for any of those webinars, please reach out to me again at russell.rivera@voicewealth.com and check your email inboxes for registration emails. Thank you again for joining us, and we will see you next week.